Good afternoon, and thank you for joining us today. I would like to welcome you to the Fortney Scott webinar entitled False Claims Act and Illegal DEI, What Contractors Need to Know. Though this webinar will be recorded, all listeners' phones are muted. Today's presenters are Fortney Scott attorneys Sarah Mugmon, Adriana Joens, and Nita Beecher. I will now turn the program over to Nita to start the webinar.
Hi, everyone. Delighted to have you with us today to talk about a subject we don't usually talk too much about, the False Claims Act. I'd like to say hello, Sarah. It's nice to have you with us.
Good afternoon, everybody.
And Adriana.
Hello, good afternoon.
And with that, let's go to the next slide. This is a webinar, obviously, by Fortney Scott, and I am happy to let you know that in addition to the webinars, which you're going to find on our resource page, we also have a number of podcasts, and today or early tomorrow, we will be dropping our latest podcast on some of these memos that we'll be talking about today, both from OPM as well as from the Attorney General. We're delighted to be talking with you today and on this very important and confusing subject right now. Next slide. So we're going to do what we've been doing for our last several webinars, do a very high level reminder of the President Trump's DEI executive orders. But our major focus today, and Sarah is going to lead us through this, is on the False Claims Act and what you need to know about it and how that's going to affect your corporation. Then Adriana is going to lead us through, along with Sarah, some recommendations on how to handle the new certification requirements, especially around DE&I and compliance with anti-discrimination laws, federal anti-discrimination laws. And finally, we'll give you some next steps of next things you need to do and in order to be able to do this new certification. And with that, so let's go to the DE&I executive orders, which we've talked about previously. Next slide. So these are all the ones starting with his initial elimination of DE&I programs within the government, President, but the one we primarily focus on is what is known now as Executive Order 14173, ending illegal discrimination and restoring merit-based opportunities. We are starting to see some memos and come out from government agencies about what they need to eliminate in addition to their DE&I programs, their DE&I offices, and we're trying to use those to give some guidance as to what the government is going to consider to be illegal DE&I. Next slide. Today, we're primarily going to be focused on the Section 3. We've talked about Section 3 of 14173, which basically creates a new certification requirement for federal contractors, which says that it's material to the False Claims Act. And Sarah, you're going to explain to us what material means. That the contractor not operate any programs promoting DE&I that violate any applicable federal anti-discrimination laws. The interesting piece that we keep seeing, though, from these memos that we'll be talking about is that they don't seem to separate illegal DE&I from DE&I. They seem to use them interchangeably. So with that, Sarah, would you kick it off and let's get into the nitty-gritty of the False Claims Act.
Gladly. So the False Claims Act has been around for quite some time. It was enacted in the Civil War era, actually, to combat government suppliers who were selling false or faulty goods to the Union Army. And what the FCA does is it creates a liability for those who knowingly submit a false request for payment to the government, as well as those who falsely certify compliance with laws or contract terms that are prerequisites for the government's payment. We get into this a little bit more shortly, but I also think it's worth noting at the outset that these FCA claims or lawsuits are filed directly in federal district court without requiring any notice, investigation, or exhaustion of administrative remedies prior to filing. Next slide, please. So A key feature of the FCA is its key TAM provisions. And this provides whistleblowers with the ability to file a lawsuit on behalf of the government for a contractor's false requests for payment. More often than not, these whistleblowers are typically former employees, but they could be any private citizen. And if the claim is successful, these whistleblowers could receive a portion of the funds that are recovered by the government as a reward.
Sarah, so let me understand this. So some employee or former employee unhappy about what they believe to be your DE&I or some other issue that came up can just file a lawsuit and potentially recover money with the government?
Yes, that incentive exists, and it is certainly a concern that, as we'll get into shortly, how 14173 has expanded contractors' potential liability to FCA claims, how these key TAM actions are a driving force of beneath the concern for contractors. To get into the process a little bit, for a government contractor, for a whistleblower, I should say, for a whistleblower to pursue a key TAM action, they file that, as I mentioned, directly with a federal district court. And that is filed under seal. So for at least 60 days, the government can investigate those whistleblowers' allegations and decide whether it wants to intervene. If successful with its FCA claim, a whistleblower could recover between 25 to 30% of the government's recovery. That is if the whistleblower is able to proceed with their claim on their own. If the government intervenes, however, the government becomes the primary litigant rather than the whistleblower. And then if successful, the whistleblower would get 15 to 25% of the government's recovery. It's worth noting that the FCA is alive and well. The DOJ has shared on its website that in 2024 alone, just under 1,000 key TAM actions had been filed. And regardless of whether pursued by the government or by whistleblowers, the government recovered $2.9 billion from FCA claims. Of that $2.9 billion, $2.4 billion came from recovery through key TAM actions pursued by whistleblowers. And as a total, those whistleblowers recovered $400 million in 2024 as their reward. So as you can see, there's a lot of money at stake here.
Yeah, but Adriana, this is not new, right? This is not new for federal contractors to have to do this a certification like this, right?
Well, no, I mean, the False Claims Act is, in fact, not a new consideration for federal contractors. The first example that comes to mind is the annual registration that all federal contractors must complete on the online System for Award Management, or SAM.gov. Federal contractors must certify and represent to the government that they are eligible to be awarded on the information that they've provided during that registration process. And in so doing, they then certify under the False Claims Act that they are maintaining, in addition to that information being correct, but they're also maintaining that information is accurate and correct throughout that annual registration period.
Wow. So, Sarah, what's next? What's the next thing they need to worry about?
Well, what separates this new certification under 14173? What makes it so different? And really, quite frankly, it broadens or expands the potential FCA liability for government contractors. And that's because, as Nita has pointed out in the introduction, that 14173 requires contractors moving forward to certify that they do not operate any programs promoting DEI that violate any applicable anti-discrimination laws. And these employers or these contractors are agreeing that their compliance with all applicable federal anti-discrimination laws is material to the government's decision to pay for purposes of the FCA. And I'll explain shortly why that materiality piece is so important. Next slide, please.
One last thought is, we talk about DE&I and what illegal DE&I might mean, but you're pointing out very important point. They also need to make sure they're in compliance with all federal anti-discrimination laws, which is above and beyond whether they have any illegal DE&I.
Precisely. And, it's always going to, it's going to be contingent on what actions the contractor has taken of whether they are in compliance or not, and how this is ultimately going to be interpreted, because it's eventually going to end up in lawsuits. How this is going to be interpreted by courts moving forward, of course, is a question that remains, and it might be some time before we find out, but nonetheless, we're in a little bit in the dark at the moment. It's needless to say, which brings me into this next slide, actually, of why there's risks. And one of those risks for contractors is that there are these undefined terms within 14173. So if you're claiming that you're compliant because you don't promote programs or DEI programs, what are programs promoting DEI? That is a term that has remained undefined up to this point. So contractors are going to have to carefully consider whether they are compliant with anti-discrimination laws moving forward prior to certifying any compliance. Otherwise, they risk these FCA claims. Now, if a contractor is found to be promoting illegal DEI or otherwise non-compliant with federal anti-discrimination laws, these potential damages or concerns include becoming a defendant in an FCA lawsuit, whether it's pursued by the government, whistleblowers, or both. And if successful, the damages that the contractor would be liable to pay include civil penalties, treble damages, and attorney's fees and litigation costs. But other penalties also would include not getting paid for their performance under the contract, or anything up to debarment. So there's certainly a lot of risk there if they're found liable under the FCA.
Adriana, have you seen anything with contractors starting to get requirements that they comply with 14173?
Actually, yes. I mean, we are actively advising clients right now on matters where they have been asked to agree to a blanket certification, where they have to confirm that they will adhere to all provisions in EO 14173. And as Sarah just pointed out, we don't have the benefit of a lot of these terms that are noted in this EO as being defined. We don't have any regulations. We don't have any guidance or anything with regard to that particular EO 14173 in that regard. But they have, but we've seen it in both contracts and in applications already. So this is something that as a federal contractor or grantee, you need to be aware of.
So what is a qui tam action, Sarah? I've always wondered what that was.
Sure. So it's made up of three things, quite frankly, and these could be any FCA claim, right? So regardless of what this, of course, is qui tam actions, but so it's what a whistleblower has to prove, but it's also what the government would have to prove to show that a contractor is liable under the False Claims Act. That first piece is going to have to be that a claim was made to the U.S. government. For our purposes today, a claim is going to be a request for payment. Then the plaintiff in these FCA lawsuits must then prove that the claim was false. And lastly, has to establish that the contractor knew the claim was false. So we've established what a claim is, but what we're going to get into now is what does it mean for a claim to be false? And when is a federal contractor considered to have known a claim was false? So when it comes to what is false, it could be factually false. And that simply means a request was made for payment of goods and services that were never rendered. Taking the Civil War era to take an example from there, this would be contractor requests payment for the sale of 50 rifles, and yet only 45 were delivered to the government. They've submitted that's a factually false claim. There could also be legally false claims. And what this means is that the government contractor has knowingly misrepresented compliance with a statutory, regulatory, or contractual precondition of payment. And a legally false claim could be either expressly made. So this actually would, 14173 actually kind of offers or requires contractors, I should say, requires contractors to actively certify that they're compliant with anti-discrimination laws before receiving payment. That is an expressly false certification. There's also an implicitly false certification. I won't get into that beyond just sharing that it's essentially unspoken compliance with contract terms and statutes by virtue of submitting a request for payment. So while not actively done, just simply requesting payment is enough to establish that the contractor has certified compliance. But again, for 14173 purposes, that would be considered a legally expressly false certification.
Well, I think for our purposes, going to the next slide, what is materially false? Because I think that's going to be something that they're going to have to deal with.
Of course. So worked into those three kind of pieces I said need to be established by a plaintiff, the plaintiff would still need to show that the false claim is material to the government's decision to pay. In other words, this means that the government wouldn't have paid for those goods or services if it had known that the contractor was in fact non-compliant with the prerequisite statute or contractual term. It's worth noting also at this point, though, that even though 14173 is now requiring or making it explicit that these payments for contracts moving forward are going to be materially tied to the contractor's compliance with anti-discrimination laws, that the Supreme Court in 2016 actually has held that labeling compliance as a condition of payment does not automatically mean that that term is material. So this calls into question the sufficiency of 14173's requirement that contractors agree that their compliance with anti-discrimination laws is material for FCA purposes. The Supreme Court has established that there needs to be something more, and that could be a pattern of the government, consistently not paying out claims when it has found non-compliance, things like that. So that the materiality, again, requirement under 14173 remains to be seen and whether that's going to hold up.
So Adriana, have you seen certifications that have been considered material that we ought to think about?
Oh yeah, I mean the federal. I'll just pull from the previous example I provided on SAM.gov. Federal contractors must complete the SAM.gov registration annually. But another requirement under that certification, as I noted, was to keep that information accurate and up to date on SAM.gov. A common violation of the FCA occurs when a federal contractor, or under the FCA, occurs when a federal contractor falsely certifies their size or their eligibility criteria, and on SAM.gov in order to qualify for government contracts. And one example would be a small business. So there's one case that I can recall where a company registered themselves as a small business, or a federal contractor registered themselves as a small business entity. But then they were acquired by another company, and with that acquisition, they no longer were eligible to win those types of contracts, but they failed to update their information on SAM.gov, and so this federal contractor was actually awarded over 100 set aside small business contracts across 20 different federal agencies over a 7-year period. So if not for the contractor status as a small business, as they had certified that they were, they would not have been eligible to receive or to be awarded these contracts. And so that is a material piece that falls, and that's a false representation made on SAM.gov. And it was considered material in the False Claims Act case that was filed against them.
Wow. So when is a submission knowingly false, Sarah? When do we have to worry about it?
Exactly. So in Adriana's example, she brings up that there is a false classification as a small business. Now, what that case also needed to require, and what all cases need to require, is that contractors have to knowingly submit a false claim. They have to know that the claim is false. That is a key component of establishing FCA liability. This is actually defined in the FCA statute itself, and it lists 3 different types of knowing. One is going to be actual knowledge. It's what it sounds like, but just to use 14173 as an example, this would be a contractor certifying its compliance with all federal anti-discrimination laws, yet knowingly still engaging in or relying on quotas for hiring or promotion, which would be in violation of anti-discrimination laws. That would be an example of actual knowledge. There's also the next type of knowledge, deliberate ignorance. In 1986, Congress amended the FCA to expand the definition of what knowledge is. And they described deliberate ignorance as the ostrich type situation. In other words, burying one's head in the sand and failing to even make simple inquiries that would otherwise alert a contractor that the claims being submitted are false. So that's the ostrich. Adriana, I think you have an example to share of how courts apply the ostrich standard.
Yes, actually, I have a pretty decent a Davis-Bacon Act case, and under the Davis-Bacon Act, you are required to file a weekly certified payroll stating that you are paying the accurate and paying the prevailing wage law, and so in this particular case, it's a recent one, so it was under the new DBA regulations. A federal court found that the general contractor on a federally funded construction project was liable under the False Claims Act because their subcontractor had willfully failed to pay the appropriate prevailing wages required by that particular project under the Davis-Bacon Act. So this decision provided a warning to general contractors under the DBA that they may not sub out work to subcontractors on federal projects. And in fact, the court had used the same language of you cannot bury your head in the sand when subcontractors or their subcontractors are willfully violating federal prevailing wage laws. So if they do, general contractors risk substantial liability for the unpaid prevailing wages and penalties under the Federal Claims Act.
As much fun as the imagery of the ostrich standard is, I'll move on to discuss the final type of knowledge that's outlined in the FCA statute, and that is going to be reckless disregard. As you can tell by that language, it is, of course, squishy. What does that mean? So it is the most subjective of all of these knowledge standards. So how this has been applied or defined by the Supreme Court is actually, as recently as 2023, described it as unjustifiable risk, equally as squishy in my opinion. However, we were fortunate enough with that court opinion that they explained or illustrated reckless disregard through an example. And in that situation, essentially, a driver's going down the road and they see a sign that says drive reasonable speeds only. And the driver has no idea what reasonable speeds are. So at some point speaks to a police officer. That police officer says anything under 50 miles per hour would be considered a reasonable speed. So the driver goes down the road and starts to realize that the cars around him are going, let's say, 45 miles per hour. He takes off. He starts going 60 miles per hour. Well, he took an unjustifiable risk. If he gets pulled over, it's going to be a challenge for him to say that he was not on notice or lacked context to understand that what he was doing was potentially in violation of that sign. That type of notice to oneself or to a contractor or context should be sufficient to establish that that contractor or individual has reckless disregard for the truth when they have that notice in that context and choose to ignore it anyway. Another case, there's another thing I do want to before I move along. There is a case I do want to discuss with you all today, and this is really highlighting how courts apply this reckless disregard standard with respect to evaluating compliance with an anti-discrimination law. This case is an appellate level case. Yes, Nita?
I think we probably need to go to the next slide if I'm right.
Oh, yeah, thank you.
Because this is really important. I want everyone who's on this call to listen carefully because this could save your bacon.
No, for sure. So this is an opinion arising out of the 11th Circuit. It is in good standing, and while not as weighty as a Supreme Court case, it certainly does offer contractors with some idea of proactive steps they can take to best protect themselves from potential FCA liability. In this case, it was a higher education institution certifies that they're compliant with Section 504 of the Rehabilitation Act in order to receive payment under Title VII of the Higher Education Act. Now, Section 504, for anybody unaware, is very similar to the same protections offered under the Americans with Disabilities Act. They're very similar type statutes. And a former employee of this university then alleged that the university had submitted a claim with reckless disregard for whether the university's policies violated Section 504. This former employee argued that the author of the university's anti-discrimination policy was incompetent and unfamiliar with respect to Section 504, and alleged that the certification signatory of the university had not independently and specifically verified the policy's compliance with Section 504. And this was the basis, amongst many other things, but for our purposes that we care about today, that was one of the bases for this FCA claim or alleging fraud. The court, however, found that the university did not recklessly disregard its compliance obligations and explained that the university's actions established the contrary. Specifically, the court listed out 4 actions that the university had taken. The first was assigning the revision of this anti-discrimination policy to account for Section 504, assigned that to an employment attorney that had over 20 years of experience. That attorney's revisions had been based on EEOC approved policies. While Section 504 is slightly different than EEOC principles, nonetheless, they're similar or analogous. And the court found that relying on that guidance was not reckless. Also, the university had taken or had regularly provided compliance training to its employees. And the last piece was had hired an outside attorney to review those compliance training materials. And so they had really, this case just offers insight into actions that federal contractors can take proactively to protect themselves against a potential FCA liability.
Well, you know, Title VI is a little different from Title VII, but the Supreme Court seemed to think that Title VI and Title VII were very similar if we look back at the Harvard UNC cases, as a matter of fact. But I think that it's really important for everyone on this call to think about You want to avoid reckless disregard so that as you think about compliance, whether with the DE&I question or with compliance generally with federal anti-discrimination laws, think about these 4 items that were useful. These were facts that upheld what the company had done and avoided FCA liability, which, as we have said, Sarah, it's treble damages plus whatever you.
Civil penalties, attorney's fees, non-payment of the contract moving forward. It's a lot.
Well, and debarment potentially on top of all of that.
Mm-hmm.
So now that we've scared you half to death, let's go to what's some of the recommendations we have about how you're going to actually do this certification. And I mean, I think, Adriana, if I can turn to you with the next page, I think we can think about what's in that 504 case that Sarah just walked through with us and how we can use that to make sure that our compliance programs and DE&I programs are not going to get us, not to be found liable under the FCA.
Yeah, that's right, Nita. I mean, we have a very good framework here of what the federal contractors can do to successfully mitigate against potential and future FCA liability. And so we want to discuss the new certification requirement, kind of to summarize that federal contractors need to certify that they comply with all federal anti-discrimination laws and have no illegal DEI programs or activities. And in order to meet the certification, then the federal contractors are going to step back and review to ensure that they are compliant with this and with all the federal anti-discrimination laws, and to ensure that their DEI programs do not in fact fall under the category of illegal. This is a crucial step to maintain compliance and avoid potential FCA issues. So we recommend that federal contractors ensure that this is done and conducted under a privileged legal audit, attorney-client privilege, and that be done of their DEI and compliance programs. We are assisting clients in this process by using the red, yellow, green evaluation system, if you will, and applying what we have gleaned from recent agency guidance memoranda and the EOs to assess the legality and risk of these programs. I need to be clear, it's internal guidance within the agency advising or directing offices and departments and agencies to do these certain specific, and that's what we're using as to proactively identify areas that need attention. Nita?
Well, I think it's important to remember, so we have gotten very little guidance and honestly don't expect a lot of guidance. But what we are trying to do is sift through this. There's an OPM memo, which Adriana is going to talk about in just a minute. We're not giving you every single thing that we found, but we wanted to pick a few just to show you how we think this works. And we are using the OPM, and then a subsequent Attorney General did 2 memos that we have looked at that I think give us a better idea of what they're going to come after both federal contractors as well as others. In fact, just to let you know, the FCA is now investigating Comcast diversity. So it's not just going to be you have to do this under the FCA if you're a federal contractor. You could also be investigated by various federal agencies as well. So Adriana, what did we find as we looked at these various memos?
Right. So the first one, first example we wanted to use, and we're applying the red, yellow, green, system that we are using. The first one we're going to talk about is the diverse slates. Diverse slates are a common practice and a best practice too. However, in a recent memo published last week by the Office of Personnel Management, OPM, and this can also be found on our EO resource page, but it's entitled Further Guidance Regarding Ending DEI Offices, Programs, and Initiatives. And it's addressed to the heads and acting heads of all the federal departments and agencies. And the memo specifically called out diverse slate policies that mandate the composition of hiring panels or candidate pools as an unlawful DEI practice, and it directed the agencies to end the use of this practice immediately. So for purposes of proactively ensuring compliance with the certification, we would, as this example shows, we would categorize this practice as red, meaning it's a high risk if the practice is continued by a federal contractor or employer. In the next example we have, we want to discuss, the next example is affinity groups. The same OPM memo states that agencies should prohibit ERGs from advancing recruitment, hiring, preferential benefits, or employee retention agendas based on protected characteristics. So you can see that at the top, we have this under red, yellow, green. And I'll explain this. It's because the affinity groups have not been completely eliminated. There are some caveats and limitations or restrictions that have been placed, and this is based on the OPM memo. The agencies can still host affinity group lunches, engage in mentorship programs, and gather for social and cultural events. But something to note is that the race or sex-based ERGs are allowed, but again, only with substantial revisions to their mission and activities. For instance, they must be all inclusive, they cannot segregate, and even the decision making is under scrutiny here, where the individual making decisions about the affinity group's activities and whether they should be approved or not, it's based on why they're making that decision, whether it is in fact all inclusive, whether there are any concerns that might be raised based on this. And so for this example, in applying the same concept to employers, it's the devil's going to be in the details here, and we're going to have to figure out, okay, based on the activity, based on who's invited, who's allowed, and those types of limitations we are going to apply, and that's why it could potentially be red, yellow, or green. It could be very high risk, or it could be low to no risk, based on the details provided when reviewing affinity groups. Nita.
It's so interesting, Adriana, sorry. It's so interesting to me because I've been involved with diversity since the early 2000s, 2003 time period. And back then, an affinity group basically was they get together and have lunch. They'd have, if it was Hispanics, they would come up with their food or things like that. And they had evolved in something much more, which was development. They would use it for development. They would use it to help and all kinds of recruitment of additional diverse folks. But it's pretty clear that if you have those activities now, you could be investigated and it could be determined to be illegal.
Well, in our final example, we're going to walk through EO offices. So this same OPM memo states that agencies should retain personnel offices and procedures required by statute or regulation. And this is to include counseling employees on discrimination, to collect demographic data, and process complaints and accommodation requests. So it's important to ensure that the EO office is engaged in anti-discrimination activities. But under this risk assessment, if you have an EEO office that handles these functions, then we would consider this low risk or no risk, or in this case, green. So something though that was noted in this is that the functions, if these functions that were listed here were at all provided or covered under the DEI offices, then there was a specification that they needed to be distributed to other departments or other offices, or to be set up under the EEO office. But if those functions were already under an EEO office, that was fine and that was good, and based on this OPM memo.
One thing that's come up and a lot of people have talked about is the collecting demographic data. And that in here is mentioned specifically, but it's what's required by statute or regulation. We have been collecting under 11246 applicant data. We are recommending you continue to look at the applicant data. And clearly, if you're collecting employee data, race and gender, based on accommodating so that you can do your EEO1, at least right now, that's certainly covered by statute. We still think it's important to look at that data so that you can defend yourself from allegations of discrimination. Again, things are evolving. It may change, but that's kind of where we are right now. Adriana?
Yes, so if we go to the next slide, we wanted to pause here and point out some additional important considerations based on what we've discussed so far. So we've been focused on Section 3, specifically the FCA certification of EO 14173. But in response to Section 4 of the same EO, the Attorney General body published a memorandum last week where, and again, this can be found on our EO resource page, but directing the Department of Justice's Civil Rights Division that they investigate, eliminate, and penalize illegal DEI and DEIA preferences, mandates, policies, programs, and activities of private sector and educational institutions that receive federal funds. And something that's pretty scary, Nita, here is that it includes the potential for criminal litigation.
That was scary. I know when that memo dropped, it's actually broader than what was in the original executive order in Section 4 rather. And I think people were, this applies to everybody. This isn't just federal contractors. So federal contractors have, in addition to the new certification, they have the potential to be found by the Department of Justice to have criminal liability. What we are hearing is potentially there is a statute that was used against Ku Klux Klansmen back in the day, and that they believe that might be possible to be used in these situations as depriving people of their civil rights in this situation. So this is very serious.
Yes, it is. Sarah, did you want to cover the three other points on this line?
Of course. I think this kind of takes it back to, the first half of this, where again, there is this exposure for whistleblower claims, and there is a very active plaintiffs bar with respect to the FCA. And I'm sure those attorneys are chomping at the bit to give this new FCA liability a spin. I think also what is worth noting or reiterating is that when an FCA claim is filed, as I mentioned, it is filed directly with the federal district court. So there is not this notice period where you get to try to fix whatever the problem is. You get slapped with the lawsuit. But I think also important to note is not just that a whistleblower can file a claim, but that then the government, which is the DOJ, has an opportunity to intervene and become the primary litigant. As the primary litigant, they have endless resources to pursue these claims. It's also worth noting that in the first piece of this first consideration we have here, they're clearly interested in trying to root out illegal DEI. However, that will eventually come clear to be defined through they're willing to go after public corporations or trying to find ways to do so. So, of course, their ability to intervene adds a little bit of an extra layer, not to always be the person that brings the scary news to the webinar today.
Well, it's important to do that anyway. All right, so we're getting, now we want to talk a little bit about what we think people should do in the interim. And just a reminder, and I know Adriana is going to mention this again, you have until April 21st, which I remember easily because it's my youngest son's birthday. You have till April 21st to sort of be under 11246. After that date, basically you're just under Title VII in that. And so Adriana and Sarah, can we talk a little bit about what we think people should be doing?
Right. So I'll start off to mitigate FCA risk proactively. Federal contractors should conduct an attorney-client privilege review of DEI programs. I know we've mentioned that a couple of times. Again, bringing up the April 21st date. This is based on that 90-day grace period that Nita mentioned. But for that review, and this is not an all-inclusive list, it needs to include, or should include, all public statements, your applicant and personnel processes, the ERGs, a review of your affinity groups, the employee advancement programs you have, scholarships, internships, mentorship programs, and then compliance with Title VII, the Equal Pay Act, the ADA, ADEA, GINA, Section 503, and VEBRA. Sarah, what is another important point in mitigating this risk?
You know, as you shared, our clients are beginning to see these blanket requests to certify that there's compliance across all sections of EO 14173. So these requests are starting to come in, and they're only going to increase. So federal contractors really do need to advise every level of their procurement team of the potential request for certification, so that they notify the proper folks that can make sure that legal counsel gets involved with the certification process. Yes, Nita.
You know, what's really interesting to me, Sarah and Adriana, is that in the past, I think going back to the Biden administration, an executive order would be issued, but it wasn't self-executing. You would actually get either a FAR clause and or regulations from, I think of the $15 minimum wage. The Department of Labor issued regulations proposed in the Federal Register. You got to, go and say, we hate these. Then they finalized them. We're not seeing any of that.
No.
Yeah, and we don't know when we're going to get that guidance. It very well may be crafted by case law. We don't know yet, and that could take some time. Obviously litigation is a slow, protracted process. So if that's how guidance, or at least definition, is gonna take shape or take form, it could be quite some time before we really get that clarity.
I have a funny story that because we've been talking serious, and we are serious, but I'm talking to my husband about all the stuff we're doing, and he said, what's the Administrative Procedures Act? I said, I live it every day. It's my life.
Yes. Oh my goodness.
I guess
Well,
we
Nita,
can say this EO is bringing awareness to a lesser known statute.
absolutely. Well, in the final bullet point, in the past, this additional mitigation of risk for FCA, in the past, a lot of our clients had a procurement department, or still have a procurement department that handles the SAM.gov annual registration, and it would probably be a good time to audit the past registration, and then also do a collaboration between legal and procurement departments. I think that needs to become a practice at this time, is just to ensure, because we're having clients already reporting to us that there is no specific acknowledgement by contract specialists or specific attention drawn to that particular provision that is being placed into that contract, or that provision, at least from our experience and what we've been receiving from clients. That there's that concern that it could potentially come in through just a simple, like a modification to a contract. And so special attention needs to be, and communication, and especially the notice, as Sarah has pointed out, to the procurement departments to be aware of this. And that way you can ensure that you're not at risk under the FCA. And in the next slide, we did want to discuss a couple additional recommendations that we have. And these are additional steps that should be taken to mitigate FCA risk, and some of which we have taken from the 504. But the first bullet is a little bit separated from that. We anticipate that there's going to be an increase in whistleblower activity with this new certification. And so as such, we believe that federal contractors with their legal counsel should also establish a robust investigation process to handle DEI concerns and complaints brought by employees. Sarah?
Course, and because there's going to be a heavier scrutiny on contractors' actions, particularly with respect to anti-discrimination laws, you want to make sure that you're taking those proactive steps that, quite frankly, are kind of essentially, you're going to need an attorney's involvement. As that 504 case I discussed kind of established, having an attorney kind of reviewing your anti-discrimination policies or your employment decisions. Also, relying on EEOC guidance that has been established as providing that type of information for employers to take into account. Those types of things you should rely on so that you are best protecting yourself against these allegations in the long run. So that's really essentially. So I keep going back to it. Always goes back to this 504 case for me. I think it really does provide that information contractors need to know how to at least take some steps and protections.
Adriana, you want one last thought before we close out this webinar?
Oh, yes, thank you. I would say the time is now. I would not wait for the end of the grace period to end and sit there, but based on these nuggets or these little tidbits of information that we're receiving, and we're kind of seeing that trend of what we can expect that will then be mirrored, if you will, onto the federal contractor and private sector as well, in addition to a higher educational institution. So the time is now to become prepared to mitigate your FCA risk, or to mitigate the liability under FCA. So this that could be my biggest recommendation after our discussion.
Well, I agree with that. Let's go to the final slide. I just wanted to mention to everyone, we have a resource page, which is really fabulous, has all the executive orders, has our podcast, and we will be dropping, as I mentioned, a podcast late this afternoon or early tomorrow, basically getting into a little more detail on the OPM, that would be Office of Personnel Management, the HR department for the federal government, as well as the Attorney General's memos. And I think that's a really good discussion about where we are from that perspective. We have our prior webinars. This one will be up there too, and also client alerts. And thank you, Sarah and Adriana. Great job. And I think we'll be doing this again probably next week on another similar topic. So Sarah, you want to take us away?
Thanks, Nita. We would like to thank you for joining us this afternoon. If you have any further questions, please email us at info@fortneyscott.com. A recording of this webinar and a copy of the PowerPoint will be available to all those who attended. This will be sent as soon as the webinar recording is available. Stay tuned for our next podcast and webinar.